Nearly 50 years ago, the Supreme Court recognized the constitutional right to an abortion in Roe v. Wade. That ruling, anchored in our Constitution's right to privacy, was part of a litany of cases forming the doctrine of substantive due process, guaranteeing constitutional protections for many of the freedoms that we embrace and rely upon in the modern United States. Whether it be a parent's decision on how to raise their child, an adult's decision to marry the person they love, or the decision to use contraception, these private, intimate choices have long been left to the individual to make for themselves, not to politicians. In the weeks since Dobbs was published, I can tell you that the people of my district in Arizona are angry. They're angry because the Supreme Court's decision to overturn Roe reverses years of hard-won progress and precedent. It threatens the lives, careers, and families they've built, and the plans they've made for their future. Simply put, it turns back the clock. While Justice Alito attempted to distinguish the right to an abortion from other personal freedoms recognized by the court in recent decades, like access to contraception, like marriage equality, his distinguishing rationale was so weak that there is little hope that other personal liberties will hold up to its scrutiny. Make no mistake, the Dobbs decision is a clear invitation to state legislatures to pass more hostile laws that, without a doubt, will result in litigation before the Supreme Court and will result in further fundamental rights being stripped away. You don't have to be a close observer of the court to know this. Today's Supreme Court majority will not stop at overturning the right to an abortion. Now, the court feels empowered and emboldened to ignore stare decisis and rewrite settled law. From Meyer, the case protecting parental decision-making, to Griswold protecting access to contraception, to Loving protecting interracial marriage, to Lawrence protecting privacy for intimate relationships, to Obergefell protecting marriage equality, a century of stare decisis is at stake. So now it's up to us, members of Congress, who are duty-bound to our voters, to take immediate action to secure our fundamental liberties through federal statute. That will require abolishing the filibuster, but protecting constitutional rights is more important than protecting our archaic rule of the Senate. Our Constitution, our country, and the American people demand it.